Land and building laws in Thailand that affect Farangs. What you need to know about Usufructs, Superficies, and Habitation Laws. If you plan to purchase land and erect buildings on it in Thailand, then there are a few things you should be aware of as a foreigner to help protect your rights. Firstly, a foreigner cannot own land in Thailand. You may pay for it, but the land must be registered in the name of a Thai national or a company, probably your girlfriend or wife. If you use a company, your Thai partners must own 51% of it. You may purchase and own the buildings which sit on the land, but you cannot own the land. If you have a Thai spouse, and purchase land and then erect buildings on that land, in the event your wife dies, the government allows the foreigner a period of 12 months to register the land in another Thai name, or they can confiscate the land. It's pretty pointless owning the buildings, if the land on which it's built can be taken away or transferred. You may have little choice or control in the matter. To protect your right to remain in the home you paid for, then it's important you seek professional legal advice on your rights. We will talk about 3 possible options and solutions for you, subject to your personal situation. 1. A usufruct agreement. A usufruct gives the right to use a property, and you obtain limited control of another person's property. The right of usufruct transfers possession, use, and enjoyment of a property, from the owner to the usufructuary. A usufruct can only be registered over properly titled immovable property, and is established by agreement with the owner, and registration at the local land office. The usufruct is the legal document that states and confirms the formal agreement between the owner and the usufructuary, the person granted the right of usufruct. 2. The right of superficies. In Thailand, there is a legal separation of ownership over the building and the land. The right of superficies is used when you build upon land you do not own. It creates the registered right to use the land and to own the structures you build upon the land, without obtaining ownership rights over the land itself. A right of superficies may be established either for
A period of time of up to 30 years, or
B. For the life of the owner of the land. C. For the life of the superficiary. A right of superficies registered for a specified term is a transferable and inheritable interest in land. 3. The right of habitation. The right of habitation concerns only the right to dwell in a house. The grantee of the right of habitation does not pay rent to the grantor. If there is a rental payment made, the matter becomes a tenancy agreement. A right of habitation may be created for either a specific period of time, or for the lifetime of the grantee. In case the rights are granted for a specific time period, the law states that such a period may not exceed 30 years. If a longer period is fixed, it shall be enforceable for only 30 years. The grant may be renewed for a period not exceeding 30 years from the time of renewal. Lastly, the right of habitation is not transferable by way of inheritance. I hope you have found this video helpful, regarding your legal rights in relation to land and buildings in Thailand. The major issues arrive when you do not trust your Tirik and her motives. Thanks for watching. Please like the video and subscribe to help the channel grow.